Hello, this is Simon Jackson from learnloads.com. This video is about the legal writ of habeas corpus, including a little about its history and looking at the legal process involved. The video also identifies the arguments against torture, explains when torture became illegal and reviews some recent problems. Firstly, habeas corpus and prison. Comedy and satire, don't you know, can get you into big trouble. In 2016, for example, Palestinian comedian Adel Meshusky, apologies if I've pronounced the name wrong, was arrested and detained for making a video about problems with the electricity supply in his country. In Burundi, also in 2016, Alfred Aubin Mugenzi was locked up for poking fun at the Burundi president. This was because his show included a sketch showing the football-mad head of state refusing to leave the soccer pitch after 2 yellow cards. When somebody is in some way a threat, nuisance, or even just an embarrassment to those in power, there may be a temptation to put that person in prison, where they're likely to be much less of a problem. From prison, it's difficult to communicate with the public at large, or even friends and family. Locking someone up is also likely to deter others from speaking out. However, in a system with even the most basic sense of the rule of law and civil liberties, prison should only be used when someone has been properly tried and convicted by a court of breaking the law. The use of imprisonment without charge or trial is a strong indicator that the rule of law is weak. Now, in Britain, the USA, and other democracies that have adopted the principles of English law, citizens can seek to obtain their release through application for a writ of habeas corpus. Literally translated, because it's in Latin, this term means you have the body. So how exactly does habeas corpus work? Well, let me illustrate with an imaginary example. Suppose that a British comedian, let's call him Russell Beard, makes fun of the government in some way during his comedy show. In the small hours of the morning, he's taken into custody by the police and locked up in Wormwood Scrubbs prison. He repeatedly asks what offence he is being charged with, but receives no reply. Through his lawyer, he asks a High Court judge for a writ, a legal document of habeas corpus that is addressed to the governor of the prison. The writ, if he gets a writ, requires the governor to physically bring the detained person, in this case Russell Beard, before the judge so he or she can be satisfied that there are lawful grounds for detention. If the judge is satisfied that the imprisoned person has been detained in prison without proper process under the criminal justice system, he'll be released. So, to sum up, the writ of habeas corpus is a way for someone in prison without proper charges in the normal way to secure their release. Habeas corpus is not something that's mentioned in Magna Carta, but it has been an accepted part of English law since medieval times. One important milestone in its history was when the House of Commons refused in 1625 and then again in 1626 to legislate for taxes to be raised for Charles I to pay for his foreign war. The King's response to this was by ordering his richer subjects to lend him money instead. A group of men, known as the Five Knights, refused to make these loans to the King, for which they were imprisoned by Charles. These gentlemen, pointing out they had not been accused of breaking any law, all sought a writ of habeas corpus to secure their release. They were actually unsuccessful, basically because the Crown persuaded the court that the detention was by special royal command. The knights eventually agreed to make the loan and were released. However, the House of Commons was outraged at what had happened. In 1628 the Commons passed a statute with the reluctant assent of King Charles, which became known as the Petition of Rights. This law prohibited the King from levying taxes or using other means of raising money to get money from the people without the proper permission of Parliament. It's also stated, and this is crucial for the habeas corpus bit, that nobody should be imprisoned or otherwise molested by servants of the Crown for refusing to pay taxes or other financial charges that had not been authorised by Parliament. Today, an application for judicial review is mostly used instead of habeas corpus. And since the Human Rights Act 1998, there's been another option, which is an application to the courts for breach of Article 5 of the European Convention on Human Rights, which is the right to liberty and security of the person. And there's also the possibility of an application under the common law of false imprisonment, but this can take a considerable time to come before the courts, whereas habeas corpus applications are treated as much more urgent. Remember that the state has the legal right to detain criminal suspects and put people in prison so long as they've been convicted by a court. So habeas corpus applications will not normally be used in relation to a refusal of bail or where a person has been given a custodial sentence after conviction by a court. Notice that there have been occasions in recent times where people were detained for lengthy periods without criminal charges or trial by government authorities in democratic states. So one instance is the detention without trial of those suspected of involvement in IRA activities in Northern Ireland during the 1970s. Another is the detention without trial of suspect Islamic terrorists in the prison at Guantanamo Bay, Cuba. The decision to locate this prison in Cuba was not a random one. Its inmates are held outside the jurisdiction of US law, so it's very difficult for them to seek the protection of the US courts and things like habeas corpus applications. Torture. Well, there are at least 3 objections to torture. Firstly, it's a cruel and unfair punishment for those who have not been found guilty of a crime. Secondly, as most of us will say anything to avoid extreme pain, it's a fundamentally unreliable way of acquiring evidence. And thirdly, the use of torture is damaging to the reputation and image of the justice system. Although at one time relatively commonplace, torture was condemned by the English common law courts from about the 15th century onwards, but it was used in England in relation to alleged offences directly against the state, such as treason, until the early 17th century. In continental Europe, state-authorised torture continued for quite a while longer. So, for example, it was not abolished in France until 1789, and in Russia as late as 1847. In the USA, torture was outlawed in 1791. Article 3 of the European Convention on Human Rights prohibits the use of torture. It also bans the infliction of cruel and inhuman treatment. This cruel and inhuman treatment could include things like using lights and noise to deliberately deprive victims of sleep for extended periods. Also, in the UK, under the Criminal Justice Act 1988, section 134, it's an offence for any state official to inflict severe pain or suffering on another person in the execution of his duties. Notwithstanding this, the UK government has allegedly, since 2001, from time to time relied on evidence against terrorist suspects that was obtained through the use of torture or other forms of cruelty. This evidence may have been gathered in Guantanamo Bay by the US military or by agents of other states in various overseas locations. To find out more about the history of human rights, please have a look at this video on the Magna Carta. And to watch lots of other Learn Loads videos, you can go to learnloads.com or our YouTube channel. If you like what you see, please subscribe by clicking the red button in the corner and/or click the little thumbs up in the right-hand corner of the screen. Thanks a lot. Bye.